Have you ever noticed how some public issues are widely acknowledged, officially documented, and yet still strangely difficult to follow? It's not that information isn't available, but rather that its release is often a slow, layered process, spread across different institutions, evolving over years. We might hear a major announcement, see headlines, and then, slowly, the initial clarity dissipates into a maze of procedural updates, legal filings, and fragmented reports. Today, we're going to slowly unpack one of the most publicly discussed processes in the United States, and yet one that remains procedurally difficult to trace. We're talking about the efforts to address the opioid crisis, not from a medical or social perspective, but from the vantage point of the complex, multi-layered institutional and legal responses that have unfolded over nearly 2 decades. It's a story not of a single event, but of an enduring process, marked by countless official statements, court documents, and regulatory adjustments, all attempting to grapple with a profound national challenge. The opioid crisis, as a public health emergency, began to gain widespread recognition in the late 1990s and early 2000s, primarily driven by a surge in prescription opioid use, and subsequently, a rise in overdose deaths. Initially, the public discourse focused on prescription practices and medical guidelines. However, a significant shift began to occur as early as the mid-2000s, transforming the issue from solely a medical concern into a vast legal and regulatory undertaking. State attorneys general, seeing the escalating human cost, began to file lawsuits against pharmaceutical manufacturers and distributors, alleging deceptive marketing practices and negligent oversight. This marked the initial formal entry of the legal system into what had largely been a public health debate, laying the groundwork for a procedural journey that continues to this day. As these initial state-level actions gained momentum, the sheer volume of cases became unmanageable. By 2017, hundreds of lawsuits had been filed across various federal courts by cities, counties, and even Native American tribes. It was at this juncture that a critical procedural mechanism was invoked: the creation of a federal multi-district litigation, or MDL, in the Northern District of Ohio. This wasn't a trial. Rather, it was a legal consolidation, designed to centralize pretrial proceedings for similar cases, manage discovery, and potentially facilitate global settlements. For the public, this announcement brought a sense of national coordination, suggesting that a unified front was finally emerging. Yet, the procedural reality of an MDL meant that while cases were grouped, each plaintiff retained its distinct claim, creating an intricate web of negotiations rather than a simple, singular path to resolution. The language used in court orders at this time began to reflect this complexity, speaking of bellwether trials and settlement frameworks rather than definitive judgments. One of the most defining and complex procedural chapters in this ongoing saga involved Purdue Pharma, the manufacturer of OxyContin. In September 2019, facing thousands of lawsuits, Purdue Pharma filed for Chapter 11 bankruptcy protection. This move immediately shifted the legal landscape. The pursuit of accountability moved from direct litigation in state and federal courts to the highly specialized environment of bankruptcy court. Official statements from Purdue Pharma, the Sackler family, who owned the company, and various plaintiffs began to appear, each framing the bankruptcy as either a necessary step towards resolution or an attempt to evade justice. The public heard about a multi-billion-dollar settlement proposal, seemingly offering a path to compensate victims and fund abatement efforts. Yet this resolution was far from final. The bankruptcy plan itself became a battleground, stretching over years. Each proposed iteration, each official filing with the bankruptcy court, brought a momentary flash of clarity regarding the distribution of funds, the release of the Sackler family from future liability, and the formation of a trust to address the crisis. In public press briefings, representatives of various creditor groups and government agencies would announce milestones: a judge's approval, a new proposed trust. But with each announcement came a new set of conditions, appeals, and further legal review. For instance, the contentious provision granting legal releases to the Sackler family was appealed to higher courts, leading to vacillating judicial decisions. Each time a federal appeals court weighed in, or the Supreme Court declined to hear an appeal, the narrative shifted, adding another layer of procedural detail. An affirmation here, a remand there, without fully consolidating the understanding of the public regarding the finality of the agreement or the operational specifics of fund distribution. We saw an official acknowledgement of a path forward, but the details of that path remained stubbornly fluid. Beyond Purdue Pharma, the MDL facilitated settlements with other major pharmaceutical manufacturers and distributors. Companies like Johnson & Johnson, McKesson, AmerisourceBergen, and Cardinal Health agreed to multi-billion-dollar settlements. These agreements, formalized through master settlement agreements and memoranda of understanding, were widely publicized, with headlines often focusing on the massive dollar figures. For the public, these announcements often signaled a conclusion, a definitive financial consequence for corporate actions. However, the true procedural story embedded within these documents was far more intricate. These master agreements, often hundreds of pages long, laid out not just the total sum, but also an incredibly complex allocation structure. They specified how funds would be distributed over a period of 18 years or more, distinguishing between payments to states, counties, and cities. Crucially, they also dictated the allowable uses for these funds, often mandating that a significant percentage be dedicated to opioid abatement strategies, treatment, prevention, harm reduction. These are not simple directives. The official language of the agreement specifies evidence-based and data-driven approaches, requiring states and local jurisdictions to develop detailed plans. This meant that while a national settlement was announced, the actual implementation was devolved to thousands of distinct governmental entities, each with its own local needs and procedural requirements. This decentralization of fund distribution and oversight is where the narrative becomes most fragmented. Each state, county, and city receiving settlement funds had to establish its own framework for allocating and spending the money. Many created new commissions, advisory boards, or dedicated offices. Public hearings were held at local levels, inviting input on how these abatement funds should be utilized. Official reports from state treasurers or health departments would detail quarterly disbursements. Yet, piecing together a comprehensive national picture of how these billions of dollars are actually being spent and what specific outcomes are being achieved remains an immense challenge. The information exists, often in hundreds of disparate state legislative documents, local council meeting minutes, and agency reports, but it rarely coalesces into a single, digestible narrative. The repeated return to official statements on spending plans or compliance updates only highlights the ongoing, unceasing nature of these procedural efforts, rather than bringing them to a tidy close. What this journey through the opioid crisis litigation reveals is not a lack of transparency, but rather the inherent nature of how complex institutional processes unfold in the United States. Government agencies, courts, and corporations communicate through specific, often specialized, channels. Legal filings are for specific judicial points. Regulatory agencies issue guidance. Congressional committees hold hearings for oversight, and corporations release earnings and settlement statements. Each provides a piece of the puzzle, a moment of clarity on a particular procedural step, but rarely the entire picture at once. The process is not designed for immediate, comprehensive public understanding, but for incremental, legally rigorous progression. The timeline itself, stretching over 2 decades and projected to continue for decades more, means that what constitutes the story is constantly evolving, perpetually being redefined by new filings, new reports, and new acknowledgments of progress, or lack thereof. Even after years of litigation, bankruptcy proceedings, multi-billion-dollar settlements, and countless official pronouncements, the full procedural story of how the nation is addressing the opioid crisis through its legal and governmental institutions remains incomplete. It is a testament to the slow, cautious, and often fragmented way our institutions process massive societal challenges. Maybe that's what makes these stories worth returning to. We'll continue exploring them together. I'll see you in the next video.